Thank you to everybody. My name is Professor Chris Marsden. I'm the Associate Director for Global Governance at the Monash Data Futures Institute, Professor in Monash Law School. I'm also an Associate of the Center for Commercial Law and Regulatory Studies here at Monash. And I want to thank both CLARS and MDFI for co-sponsoring our event that we have here today. In fact, co-sponsoring the second of our special events on the AI Act in the last fortnight. I also, before we do start, I want to acknowledge the people of the Kulin Nations on whose unceded lands we are gathered here today. I pay respects to their elders past, present, and emerging. I also want to mention that this is, I believe, the 9th seminar in the AI Act saga that we've been dealing with. And our speaker today will, I'm sure, talk even more about the saga than we have. On my very first day at Monash, at the end of March 2022, I actually gave an online talk for the Parmadiso seminar series on the AI Act, which was then so close to being decided. Then we had the inaugural AI summit in Prato that summer, European summer, second summit in 2023, at both of which we actually had specialist panels dealing with the AI Act and events around that. We also had a series of workshops with our Monash University Alliance colleagues at Warwick, in Warwick itself, at Prato, and in Brussels, which seems appropriate, dealing with those issues. We also had the Responsible AI workshop in November of 2023, at which 3 colleagues joined us from Europe, Lillian Edwards, Derek Macaulay, Mac, and also Phoebe Lee from Sussex, my old university. And then many of you in the room will be, and at home will be aware that most recently we, of course, had Nora Learden from the Institute of Advanced Legal Studies in London, speaking to us about the human rights impact assessment elements, fundamental rights impact assessment elements of the AI Act. So I'm delighted that this won't be the final seminar, I'm sure. Now I've listed the ones we've had to date, but the latest, I think, maybe the most forward-looking and also slay many of the myths that American corporations delight in telling gullible lawyers around the world about the AI Act. Hope I'm being fair to this. So I'm delighted that we're hosting Dr. Kris Shrishak today. Kris is a public interest technologist from Darmstadt in Germany, but working with the Irish Council for Civil Liberties. Kris has been in the trenches of the negotiation of the AI Act for the last however many decades it is that we seem to have been negotiating the thing. And it's a huge pleasure to have Kris with us. For our online audience, Kris will mainly be in front of you, but you have slides being shared. And for our in-person audience, I'm delighted to present Dr. Kris Shrishak. Thank you, Kris.
Thanks, Chris, for the introduction. So one Chris to another Chris. I've called my talk the AI Act Persistent Frailties, to emphasize that despite the whole fact of the saga and all of it, it's still a wounded patient. That's how I call it. So that's me. I work at the Irish Council for Civil Liberties. In particular, I work with what we call as the Enforce Unit, because we work a lot on enforcement of regulations, but also making regulations enforceable when they're being written. Because first they need to be enforceable on paper, and then we need to take action. So it takes various forms for us to take action. And one of the key things I work on is the Artificial Intelligence Act, which means working a lot with legislators in Brussels. The building on top is one of the European institutions. I'll leave it at that because there are too many in Brussels. And when you hear about the AI Act, or in fact, many of the AI governance mechanisms and policies, you'd hear the word balance. You'd hear we need to balance innovation and fundamental rights, for instance. And more often than not, you think when we talk about balance, something like this, right? You're weighing two sides and you're trying to find a balance there. I often think of balance more like this. It's like a tightrope, where if you lose your balance of the kind of policy and you want, it could be fatal. It's a different form of thinking about balance, and I think that's how we should be thinking about when you think about balance here. It's not about innovation or human rights being balanced on a scale, but rather human rights on a tightrope, and we should maintain that. And one way to think about that is to align your rights and innovation in a way where the innovation is driven by rights, right? Rather than assuming innovation would go against your rights. And when it comes to the Artificial Intelligence Act, you'd see media articles, something along those lines, right? Deal is struck, or as some like to have a competitive element in their headlines, like the EU reaches a deal ahead of, or is racing ahead of the US. Despite the fact that at that point, this was in December 2023, China already had a couple of sector-specific regulations. So there are so many countries that are working on various aspects of AI regulation. And the way I think about the Artificial Intelligence Act is more like a wounded patient. It arrived heavily wounded, has to be patched up, and it has been patched up. But it's a surviving patient. It's not a thriving person. And right from the beginning, the AI Act was primarily in terms of AI systems for intended purpose. That's because it was built on the framework of product safety, thinking of AI systems as products. So when we say products, think about toys or drilling machines, where they usually have certain purposes, and that's what they're designed for. Now, as many of you in the room would know, that is not necessarily the best framework when you think about AI systems. And it took a while, but at this point, we've moved ahead, and we do have additional components in the AI Act, which also talk about general purpose AI systems. If you don't like the term, just like I don't like the term, think about it as AI systems which have potentially multiple uses and purposes as opposed to a singular purpose. And intended purpose is interesting because you'd see triangles like this. If anyone of you have seen pictures from the European Commission, you would have seen a triangle like this, except mine is a little bit different. It has a big green part to emphasize that much of the triangle is not regulated. So most AI systems on the market will not be regulated by this regulation. That's an important part to emphasize. And so what is regulated? It's this thing on the top. Very small, very few AI systems, and that's for good reasons, right? And even in that, you'd want to know what exactly is being regulated and how. First up, certain uses are going to be prohibited. And then there are high-risk use cases, which is what the bulk of the regulation addresses. And there are a few other use cases where transparency mechanisms are going to be placed. The first example I'd like to give when it comes to prohibition, which was not in the regulation when it was initially proposed in 2021, is, I just call it the Clearview AI prohibition. Because what the text says essentially is the prohibition of scraping of facial data from social media and CCTVs for development of facial recognition databases, which is what Clearview AI does. And this is despite the fact that actually the EU's data protection regulation already covers it. But enforcing that has always been challenged. The company has been fined plenty of times. They've never paid any fines. The other one is social scoring. Now, the EU kind of thinks that China has one social scoring system, but any one of you who's actually looked into it would know there are multiple systems in different provinces. But in some sense, a variety of these would fall into this kind of prohibition. And actually, there would be guidelines, hopefully soon, which will give more details on how these prohibitions are supposed to be interpreted. Then there's this partial prohibition of real-time biometric identification in public spaces. So in particular, the one that most people would think about here is facial recognition systems in public spaces. I say partial because it is going to be allowed under specific circumstances for law enforcement agencies. and would essentially fall under the high-risk use case when it's being used. A sad one here, and as you can see, there are two sad emotions here, is that emotion recognition will be prohibited under two specific cases, so employment and education. But in other cases, it's actually going to be treated as high risk, despite the fact that most of the evidence we have says that it actually doesn't work. So scientifically, it's not even proven. So it's kind of like it's moving emotion recognition from a gray area into actually, in some sense, legalizing it when it's not prohibited. And then there are all these other high-risk examples where, for instance, we've already mentioned the exceptions from prohibitions that become high risk. We also have employment uses, think about passport control, and various others, so such as judiciary and all of that. Instead of going through all the list, I'm just giving a couple of examples. And I said much of this regulation is going to be about high-risk uses, and there are various obligations. And the first one is as simple as risk management, which is fantastic. The key point I'd like to emphasize when it comes to risk management is that now the law actually says that risk management and assessment of risks should include not only individual AI system, but the interaction of AI systems with other AI systems if there are. Now, if you've used things like ChatGPT, you might immediately recognize that you could use the output from there into another system. But this can, of course, be true in other kinds of AI systems as well. And it's an important aspect because when we don't consider the environment in which the systems are being placed, we are not adequately looking and addressing the risks. We also have data governance, which is fairly broad, but think about aspects such as where the data comes from and how it's been cleaned, has it been filtered, has it been processed, all of those elements which are important that they come in here. This applies across the board. So training data sets, validation data sets, testing data sets, and if you're using reinforcement learning, whatever data you use. And the other thing I should emphasize here is the Act does mention a lot about transparency for high-risk use cases, but the transparency is not to you and me. It's to those who are deploying. So those developing AI systems, high-risk use cases need to be transparent to the deployers. And a useful one, human oversight. The Act actually does mention and actually clarify that it can't be a tick box exercise. So someone with responsibility needs to be in the loop, so human in the loop. And the most useful one, I think, is actually also about accuracy, robustness, and cybersecurity. And here, in fact, accuracy is to be interpreted more as a performance metric, because as you'd know, accuracy is just one of the kind performance metrics. So despite the word accuracy being used here, it's to be interpreted as more as performance metrics, because in some cases, accuracy may not be the right metric. And despite all these obligations, in most cases, these are self-assessments. So no one's actually looking over the company's shoulder to check if they're actually doing these or not. And that's useful and important to mention because often the narrative is it's heavy burden, you need to pay third-party auditors. Not necessary. Companies might wish to do that for various other reasons, but it's not necessary by law. And companies could also rely on harmonized standards, which are essentially standardization mechanisms in the EU, and they essentially have legal effects. So, for instance, you might think of standards from ISO, and EU has similar organizations. And in some cases, they might just adopt ISO standards instead of building and developing their own. And so all of this is possible. And once you use these standards and can say that you tick the boxes based on standards, you actually don't need to rely on the law and the legal text. So all of that was about developers. What about deployers? Because there'll be way more deployers of these systems than actual developers in most cases. And one thing that, if you've been in the lecture a couple of weeks ago, and that's the only one I'll emphasize here, is the fundamental rights impact assessment, because that is one where a lot of civil society organizations and academics played a heavy role in actually getting it in there in the first place. The emphasis there, of course, is that despite having data protection laws in the EU, data protection is not the only right that you need when it comes to AI systems. There are various other fundamental rights that could be affected, and all of that should be accounted for. But the fundamental rights impact assessment is fairly limited despite its inclusion. So it's mostly only for public sector organization. And the argument, as usual, is that the burden would be too high for companies. What about transparency? Well, some use cases are not necessarily treated as high risk. So think about chatbots in general. So it could be a health insurance chatbot or any other chatbot. What is key here, at least according to the law, is that you should be informed that you're not communicating with a human being, but with a chatbot. And similar obligations for fake news, well, actually in this case, not fake news, but essentially fake images or deep fakes. And as you'll immediately realize, these transparency obligations do not necessarily help you beyond the fact of knowing that you're interacting with images and computer-generated stuff. And in many cases, actually, in cases where you'd really be concerned, where someone is intentionally trying to manipulate, these obligations are kind of useless. Because if I want to manipulate you, I would, of course, not be labeling my images. So it's kind of a very, very weak aspect of this law.
Or label them and don't make them fake.
Yeah. That's all intended purpose. It's all fantastic. But many of us already back in 2021, when this law was initially proposed, have been telling lawmakers that that's a very narrow view. You need to think about these broader set of AI systems. And back then, we were giving examples from GPT-2 and GPT-3, where there was already lots of literature on the risks, security risks, privacy risks. There were so many issues that we were already identifying and seeing, and we are still seeing the same thing now. So fortunately, the lawmakers did see some sense there. They had actually worked out much of the preliminary text when ChatGPT was released. Despite the fact that you might read in the media saying lawmakers are being reactive, they had actually prepared much of the text much before. And of course, these large general purpose systems in some sense are not only text generators. So ChatGPT is one example, which is more of a UI to GPT-3 or now GPT-4, but also image generation, video generation, all of that. But also worth emphasizing, the law only says general purpose. It doesn't specify all these obligations only for generative AI systems, despite the fact that the current iterations are primarily generative ones. So the generative ones will have a combination of these obligations from general purpose and then those transparency obligations. But these obligations for general purpose could, in future, depending on what comes out on the market, apply also for other non-generative general purpose AI systems. Instead of a triangle, I'm going to give you more of a rectangle in this case. And to emphasize that for most of the general purpose AI systems, it's going to be transparency obligations. Yet again, I'll say it again later as well, the transparency is not to you and me. It's to downstream companies in most cases. And you might think, what's this small red line right at the top? Some of these systems are going to be treated as systemic risk. So the transparency obligations are downstream. So primarily thinking about supply chain. And a lot of that obligations in terms of transparency is going to come in the form of technical documentation. Where did you collect the data? What kind of process did you do? All of that primarily comes in, but also more basic information like when did you actually develop it? Which iteration it is? So also what inputs went into it? What kinds of outputs can you get? Can you get text? Can you get images? Can you get audio? What are the limitations? All of that, right? So data, and where did it come from? what kind of cleaning methods did you use? That's sometimes very useful because if you've seen many of the current generation of generative AI systems, you'd notice that some of the initial versions kind of generate all kinds of texts, but then there are filters put in, or some might call guardrails, and all of that needs to be explained here. Also worth emphasizing that there is an element which says companies need to provide a detailed summary of input content. For anyone who's looked at any kinds of data while developing or trying to understand AI systems, you'd know that what is a detailed summary? Like, what are you supposed to do with it, right? And when is it a sufficiently detailed summary? The sad part here is that this whole thing is not being considered from a general public perspective, but more from a copyright perspective. And because copyright in the EU, I'm not sure how it is in Australia, in the EU, it's primarily an opt-out mechanism. And these detailed summary are intended to address the issues that copyright holders face, which is that they don't know what goes into these systems. So they at least need to know whether the content that they have created, that they use IP protection for, is in there. And only then can they go to these companies and say, I'm opting out. So that's the reasoning. And as vague as it is, there's going to be guidelines that will come through and a template that is going to be generated and sent out so that all the companies come up with a similar kind of information. And that's supposed to be useful, of course, for others who have copyrighted content. But all of this transparency, I kind of think of it more like this. You have all the information. It's like, here's my Campbell's soup. Here are all the ingredients. And now do what you can. I'm free. I've done my job. It's all up to you. I'm leaving it up to you because I've given you all the information, right? And that is not sufficient. So it's a fairly limited amount of obligations, I'd say. And we said systemic risk. What is systemic risk? It's not defined well, first thing. But I put this image because, and if any of you have followed High Jump, this is Dick Fosbury, who was very famous for Fosbury flop. And the systemic risk is going to rely on flops, which is floating point operation on computers. And that's essentially like a basic level of assessment of what kind of operations are being performed in computers. And that is currently going to be the primary way that these general purpose AI systems are going to be assessed whether they're systemic risk or not. I actually think that's not the best way, but fortunately, it can be updated later. But currently, it's going to be, for mathematicians in the room, 10 power 25 flops. For everyone else, it's just 10 trillion. So 1 followed by 25 zeros. That many flops. You might think like, okay, is this high? Is this low? And this is essentially the question lawmakers were asking in the middle of the night when they were negotiating this. And I'm not sure if it's funny or sad, but at one point the discussion was, should we have 10 power 24, which would actually bring in most of the generative AI systems in the EU market, at least within scope of systemic risk, or should we have 10 power 26, which at that point they didn't know that there were 0 AI systems on the market that would have fulfilled. And their question was, is this high? Is this low? What should we do? And eventually, we convinced them that at least GPT-4 should be within that, right? At the minimum. And they were like, yes, we agree. So what number should we go for? 10 power 25. Okay, good. We'll go. And the way they thought about it was more like, we are compromising between 10 power 25 and 10 power 24 and 10 power 26. They thought it's halfway. Anyone with basic math would tell you that that's actually not a half. Because they are an exponent, but that's lawmakers for you. So we fortunately do have GPT-4 in there, and now we also have Google's Gemini in there. So we have 2 products on the market which would be considered systemic risk, which is a lot of work for lawmakers to do for just 2 companies, but that's where we are. One additional requirement that companies who have products which are treated as systemic risk have to do is cybersecurity assessment. Now, you might wonder, shouldn't this be a requirement for everyone? Turns out lawmakers don't think so. They think it needs to be systemic risk, which whatever that means in this case, for companies to perform cybersecurity assessment. We also have red teaming, and even there, it doesn't need to be third party. You can have your own internal red team to do these assessment. Still better than not having any of that. Oops, yeah. Obligations are good, all of that is good, but if you can't enforce the law, there's no use. So how are we going to do that? Well, there's going to be, in some sense, 2 different mechanisms. One for the first set, if you're building AI systems for intended purpose, so high-risk use cases mostly, then most of the enforcement is going to happen in individual member states. So 27 member states in the EU, and hopefully, because I live in Germany, I'm hopeful that we won't have 17 regulators in Germany, just as we have for data protection, but it's possible. So it's going to be decided in member states. But then there will be a coordination between these regulators to make sure that 10 countries together, each of them going after the same company, is not wasting resources. When it comes to general purpose AI systems, we're going to have the regulator at the EU level, so more centralized. And in fact, the regulator is already formed and established a couple of weeks ago, and they call the AI Office, which is going to be part of the European Commission, which is the executive body in the European Union. What can regulators do? At a minimum, they can request documentation. Remember, we said all the obligations, they don't require any kind of third-party assessment for most use cases, most high-risk use cases. But in principle, they're required to have the documentation in hand. So when the regulator comes and asks for them, they have, I think, 30 days to produce that document with all the information. An interesting one also is that the regulator can perform unannounced on-site and remote investigation. So the first part actually comes from the existing legal framework, which may or may not be used, because it's nice that the regulator can go to a data center and to an office and bark on the door, but they may not actually get much information, especially, for instance, if you're going to do a cybersecurity check. It's nice to go to the data center, but it's even better if you can do remote investigation. And there's the possibility to access source code of during investigation. This won't likely be used in most cases, but there are certain cases where it could end up being useful, especially when a company is trying to hide information. And in fact, one of the best examples is actually from Australia, where the Australian Consumer Protection and Competition Authority had got access to the source code to identify, I think this was the German company Trivago, in a case where they found the information in the source code, which they couldn't find in any of the other aspect, be it input-output checks or documentation about what they were doing. So in that case, source code was useful. And this was actually the example we used to convince lawmakers that source code could potentially be useful, and regulators should have access if required. A useful addition also is they can actually have access to independent panel of experts during an investigation, which is generally pretty hard, but it's very useful because many regulators are under-resourced, and they will likely remain under-resourced because of funding, but also because it's very hard for them to find people, for instance, technologists and people with other expertise. So they can rely on independent experts in some cases. I'd like to emphasize that when it comes to law enforcement use of real-time biometric identification, so in this case, for instance, think about facial recognition systems, because law enforcement agencies are only allowed to use it under a narrow set of circumstances, they have to actually report to the regulator whenever they use this possibility, because it's an exception to the prohibition. And this is one limited form of accountability that is built in so that this exception is not being exploited. And once regulators are informed about this, they also have to summarize it in a regularly and send it across to the European Commission. Right. Finally, the AI Office, which is the union regulator for general purpose AI systems, they have the obligation of monitoring the market, but the monitoring is not only about enforcing the law, but also potentially updating the law. So there's a lot of flexibility built in because regulators are also learning what's going on. So they're going to monitor, for instance, if computation of the newer versions of general purpose AI systems are much, much lower, but have equal capabilities, then those thresholds we spoke about with Flossbury flops, those can eventually be reduced. And this kind of evidence needs to be collected. So they're going to be monitoring the market. And of course, evaluating if the general purpose AI system developers, but also various deployers are actually fulfilling the obligations. So ex post evaluation. And the best part, which I like, is they will be relying on external experts. And here there are actually two categories. One is an advisory forum, which would bring in various kinds of expertise, including law, policy, and technical expertise. But there's also going to be a scientific panel, which will have a significant role in flagging cases on the market. And then an investigation can be taken up. So I think that's a very useful thing to have. Finally, you might wonder, you're talking so much about law and everything, what about the people? So in 2021, the law had no mention of people, not at all. So if you see the old text, you'll go and see that it used the word users, but they were referring to deployers of AI systems. Fortunately, at this point, we do have not only mention of people who are affected by these systems, but they also have the possibility to lodge complaints. Unfortunately, this possibility does not give them legal standing in court cases. So you can go to your regulator and complain, and the regulator might take action based on the complaint, but you don't have any standing, which means if they don't take action, you can't do much. And it also means that if the investigation does go to a court, for instance, you would not have any access to the documents. This is all to say, it's a lot of patchwork being done. There are some improvements in the last almost 3 years. Almost 3 years. But it's not what one might call as an ideal scenario. So fortunately, I don't work for the European Commission, so I don't need to come and tell you this is the best in the world, because it isn't. So take the good parts, but don't take it as it is. Thank you.